Hello everybody, welcome back to my channel. So today in this video we're gonna learn another topic of law of tort, that is nuisance. Okay, so what is nuisance and its characteristics, essentials and case laws important regarding this topic you will find in this video. So please watch this video till the end. But before I begin, I request you please subscribe to my channel. It will just take your 1 second, and hit the like button if you find this video helpful. And if you have any queries, questions on this topic or any other thing, you can ask me on the comment section, or you can also follow me on Instagram. So my Instagram link I have given in my description box, where you can find and follow me in there. And apart from this, if you want to prepare for the Assam Judicial Service, if you want to learn how to prepare and everything, all the strategies, booklets which are important to the Assam Judicial Services, everything, I have created a playlist on my YouTube channel. You can visit to my YouTube channel, where you will find the playlist of the Assam Judicial Service, where you will get everything in detail. So please check it out. Okay, so let's start today's topic. So today's topic we have nuisance. Okay, so what is nuisance? So according to the Winfield, if you see the definition of Winfield, okay, Winfield, nuisance is a unlawful interference with the person's use or enjoyment of land or some rights over it or in connection with it. Okay, so guys, if you see the definition of the Winfield, then nuisance is unlawful interference with the person's use or enjoyment of land or some right over it or in connection with it. Okay, it means that like it is an interference which is unlawful on the enjoyment of the land. So let's take the example. It will be easy for you to understand this definition. So this is a land, okay, of the plaintiff. Okay, this is the land of the plaintiff, and there is a defendant. Okay, and he intentionally causes interferes on the land of the P, okay, the plaintiff, which restricts the P from doing his day-to-day activities in his premises, or say like he was disturbed by him, or say like he was adversely affected due to the acts of the D. Okay, he is not able to work in his premises. So that is called nuisance. Okay, that is called nuisance. Okay, so this could be, so there is a difference between nuisance and trespass. Okay, in our previous class we have discussed about the trespass. If you haven't watched that video, I request you go there and watch the trespass video, and after watching that video only, the topic of nuisance will be easy for you to understand. Okay, so yeah, so it is how the nuisance is different from trespass. Let's understand. Okay, so in case of the trespass, the person has to go to the land of the another person. Okay, but in case of the nuisance, the person, it is not necessary that the person has to go there. Okay, like even if he is like defendant in his own premises, but like by doing certain acts which causes the discomfort to the P, okay, the plaintiff, so that will be a nuisance. Okay, so it could be interference by any means. Okay, by gas, electricity, fumes, water, some germs, disease producing germs, etc. Okay, so this could be like the nuisance can be created by anything. Okay, and this could be done by the gas, electricity, fumes, dust, noise, smell, odors, or some disease producing germs, anything. Okay, suppose D intentionally what he does, like intentionally plays a music, okay, at a very high volume, okay, plays a music at a very high volume, so which creates the P disturbed, and P has lost his peace of mind because of the music because of the very loud music that is being played by the defendant. Okay, so that is called nuisance. Okay, so that is what, that is the interference with P to enjoy his land, right? Because he is sitting in his premises very peacefully, and because of the sound that is being created by the defendant that causes the irritation to the plaintiff, so that kind of interference will be called nuisance. Okay, I hope you understand this thing. So to summarize this, like in the plain meaning, if we have to say, then what is nuisance, then it will be like, it is an interference with the interference with the person's safety, health and comfort. So when, like, the person's safety, health or comfort is being deteriorated or disturbed or interfered by the act of another person, that will be nuisance. Okay, so let's take another example. Like suppose this is the land of the plaintiff, okay, and there is a defendant. Okay, so this is the land of the defendant. Okay, what defendant does, like, if he plants a tree in the plaintiff's land, okay, if he plants a tree in the plaintiff's land, that will be what, that will be definitely a trespass, right? But what is nuisance? But he planted a tree in his own land, okay, but the branches and the roots are projected over the land of the plaintiff, so that will be what, that will be a nuisance. Okay, so that is a nuisance. I hope you understand this thing. And trespass is actionable per se, that but in an action for the tort of nuisance, special damage has got to be proved. Okay, so in order to file a case or civil suit regarding the nuisance, then a special damage has to be suffered by the plaintiff. If there is no just by suppose, as we have discussed in that example, that planting a tree in the land, but the the branches and the roots are projected over the land of the defendant, okay, over the land of the plaintiff. Okay, so in that case, if P is not getting any disturbance due to that branches and the roots of that tree, so in that case there will be no nuisance. But if due to that branches or say roots, like plaintiff is getting disturbed, all the leaves of the tree and fruits which are fruits of that tree is falling in his land, okay, falling in his land, or say due to that tree there is a blockage, that the direct sunlight is being restricted. Okay, so there is a sunlight, okay, so the sunlight is being restricted due to that tree, so in that case P has suffered a substantial damage. So definite to in order to file and to sue defendant, the plaintiff has to suffer a damage, okay, a substantial special damage to file a suit for nuisance. Okay, otherwise he cannot. Okay, otherwise he can file a suit for the trespass, but for the nuisance he has to suffer special damage. Okay, very simple. So now we will see the kind of nuisance. I hope the nuisance is clear to you. What is a nuisance? So we'll discuss now the kinds of nuisance. So kind of nuisance. Okay, so there are two kind of nuisance. There are two type of nuisance. Number one, public nuisance. Okay, number one, public nuisance. So what is public nuisance? Okay, first we'll discuss this and then we'll move to the another nuisance. Okay, and number two nuisance is private nuisance. Okay, private nuisance. Another is private nuisance. Okay, so what is public nuisance? Okay, so public nuisance is a nuisance that is being created or say like it is an interference. Okay, it is an interference with the right of the public in large. Okay. So it is an interference with the right of the public in general. Public in general, and it is punishable, as an offense. It is punishable as an offense. Okay. So private nuisance is a civil wrong and public nuisance is a criminal wrong. Okay. So public nuisance is always a criminal wrong generally. Always a public nuisance is always criminal wrong unless a particular special damage is being suffered by the plaintiff. Okay. So in other words, interference with the right of the public in general, and it is punishable as an offense. Okay. So the reason behind why the law made it the public nuisance as a crime. Okay. The reason behind making the public nuisance as a crime is that the law sought to avoid multiplicity of suit. Okay. Multiplicity of suits. Okay. So the reason, which means like if the law has made the public nuisance as also a civil wrong, then what would happen? Every person who has got disturbance due to that act, okay, that will be and every person will get the right to sue the defendant. Okay. So there will be the multiple suits, so it will be difficult for the court to determine the rights over the particular the nuisance. Okay. Suppose there is a highway. Okay. There is a highway, and what the defendant does, he created a trench here. Okay. By digging he created a trench, or say the defendant has constructed a wall or something. There is a construction, due to that many people get affected, they couldn't go to that side. So and the defendant does it intentionally. Okay. So in that case, like this is an example of public nuisance. Okay. But in that case, if the court would have allowed that if the law has treated the public nuisance as a civil wrong, then what would happen? There will be the number of people who passengers of the people, there will be a number of people, and if that people are being restricted or they are not allowed, that is not possible for them to go to that side. So many people has got disturbance due to that act of the defendant. Okay. So in that case, if the court would have allowed as a civil wrong, then what would happen? The many people, as much as people would have gone there, every person would have got the right to sue the defendant, is not it? And there will be what? So there will be a multiple number of suits. So that is why the law wanted to avoid the multiplicity of the suit. Okay. So that's why the law created the public nuisance as a crime. Okay. So that the defendant could be held liable entirely at once. Okay. And but in case of the public nuisance also, the plaintiff has the right to file a suit as a civil wrong. Okay. Suppose this is a public way and there is a trench which is being created by the defendant, and because of that many people is getting affected. Okay. Many people has got irritation because of that. So here in this case, if one person especially get the special injury, okay, special injury apart from that injury which is being suffered with other people, if any person who has got special damage, so in that case he can particularly file a suit for nuisance as a civil wrong. Okay. Public nuisance as a civil wrong. Okay. Otherwise so public nuisance is generally a crime. Okay. I hope it is clear to you now. So there is a case law, Dr. Ram Raj Singh versus Babulal Babulal 1982. So 1982, yeah. So in this case, what happened? The Dr. Ramraj Singh, who used to be a medical practitioner, okay, medical practitioner, and the Babulal, and he is a plaintiff, and the Babulal is a defendant. Okay, so what the defendant does? So defendant, constructed brick grinding machine. Okay, so the Babulal has installed the brick grinding machine near the premises of the Dr. Ramraj Singh. Okay, he is a medical practitioner, and near to his chamber, the Babulal has constructed the brick grinding machine. Okay, so due to that machine, okay, because of that, the brick grinding thing, what happened? Whole the nearby atmosphere got polluted. Okay, so all the atmosphere got polluted, and because of that, the Dr. Ramraj Singh has suffered a lot of disturbance, and his patients also getting disturbed because of that brick grinding thing. And most of the dust which is being created during the brick grinding, that comes to the that used to come to the chamber of the doctor, and that could be visible, that all the reddish particles, dust particles, were visible on the clothes of the doctors and patients who visit here. Okay, so because of that, like, Dr. Ramraj Singh has suffered a very very irritation, or he was really disturbed because of the act of the defendant. Okay, so though there is a number of people, around there. Okay, there is a number of people around there. He is not a particular person out there in that locality, right? There are many people surrounded by the Babulal's brick grinding machine. So yeah, the many people were getting disturbed, but since and it is an example of the public nuisance, right? He has created the nuisance around for the atmosphere, because all the atmosphere got polluted, right? So here, but the Dr. Ramraj Singh has particularly suffered an injury because he is a medical practitioner, and as we can see that in all the hospitals, there is a very cleanliness and all these things, like comfort is being like the main motive of the hospital to serve the best treatment. And due to that, the dust particles, the Dr. Ramraj Singh was not able to maintain the hygiene of his hospital. So that's why he has suffered this special injury. Though there are many people who has also suffered injury, but he has suffered a special injury. So that's why he filed a civil suit. Okay, civil suit, not a criminal, civil suit against the Babulal, and the court granted him the award that, and asked the Babulal, there was a permanent injunction. Okay, the court has issued the permanent injunction against the Babulal to stop the brick grinding machine there. Okay, so this is what the public nuisance is. I hope it is clear to you now, that Ramraj Singh case and the Babulal case is also clear to you. I hope you understood. If you still have any doubt, you can ask me on my Instagram, or you can comment down below. Okay, and this case is really important. If you're writing the questions regarding the nuisance, public nuisance, then you have to mention this case. This is the most important case of public nuisance. Okay, so now we will see the private nuisance. Okay, private nuisance. So what is private nuisance? We will see. Okay, so to constitute, there are the three essentials. Okay, number one, unreasonable interference. Unreasonable interference with the enjoyment use of land and special damage. not special, it's a damage only. Damage. Okay, so there are three essentials of the private nuisance, that is unreasonable interference, and which is with the enjoyment or use of the land, and number 3, the damage. Okay, so unreasonable interference. What is unreasonable and what is reasonable? So let's understand unreasonable interference first. Okay. So interference may may cause damage to the plaintiffs interference may cause damage. I have written twice. Okay, interference may cause damage to the plaintiff's comfort or safety, anything. Okay, anything, so that will be unreasonable. Okay, like interference may cause to the plaintiff to his comfort or safety or anything. Okay, but we need to understand this thing, that every nuisance is not a nuisance. Okay, every nuisance is not a tort of nuisance. Okay, every nuisance is not a tort of nuisance. For example, okay, if I have a house, every nuisance is not a tort of nuisance. So I'll give you the example. With this example, it will be easy for you to understand that if I have a house near the highway. Okay, this is the highway and I have a house there. Okay, so there is a normal traffic sound is normal, right? If I always get to hear the normal sound, like there is a horn of the vehicles moving around the highways, so there will be normal sound of the vehicles moving on the highway, right? So I cannot file a suit for that. Okay, because though I am getting physical discomfort because of that noise created in the highways because of the vehicles which moves around here, but still that is a nuisance, and which is causing discomfort to me, but still that is not unreasonable, that is reasonable. Okay, unless and until it is like all the let's suppose however this is not possible, like all the people all the vehicles turned their face towards his house and started horning, then then what happened? Like that will be a special damage to him. Okay, otherwise if the vehicles are moving here nicely and with that little bit of noise or with that irregular noise, if he is getting disturbed, then like that is not a nuisance. Okay, that is not a nuisance under the tort. Okay, we cannot say that is unreasonable. Okay, or another example, I cannot file a suit. I cannot file a suit against my neighbor. Okay, if he is listening a radio in his premises at a very soothing sound. Okay, unless he is created like he increased the voice such a loudly that is causing discomfort to me. Okay, otherwise if he is listening to the music at his premises, so though I am not liking that music whatever he is playing, but still that's not a nuisance. Okay, that's not a tort of nuisance. All right, unless and until he has increased the volume in such a loudly, then that is a nuisance of under the tort. All right, so I hope it is clear to you what is public nuisance. So unreasonable interference. Okay, we are discussing 3 essentials, right? So under this we have another case law, Radheshyam versus Gur Prasad 1978. So in this case, what happened that Guru Prasad and another filed a suit against the Radheshyam. Okay, Radheshyam was a defendant and Guru Prasad was a plaintiff. Okay, and Guru Prasad and others filed a suit against the Radheshyam in order to restrict him from installing a flour mill. Okay, flour mill. Okay, in their premises. So there is a, suppose there is an apartment. Okay, this is the apartment, and suppose say 4 or 5 like multi-story apartment. Okay, so there is a society, many people are living there. So Guru Prasad and others were like filed a suit against the act of the Radheshyam. Okay, he was supposed to construct a flour mill in the second floor. Okay, first floor of the house, of the building. So because of that, if he installs that flour mill there, that will cause what? That will cause a nuisance, that will create a lot of sound and noise. And as we have seen in the previously, that nuisance can be created either by gas, fume, sound, noise, anything, right? So if he installs a flour mill there, so that will cause a nuisance to the people living in that building, right? So that's why the people have filed a suit against the Radheshyam in the court to prevent him from constructing or installing flour mill there. Okay, and the court give the permanent injunction against the Radheshyam, and he was restricted in making the flour mill. Okay, the case was like that. So this was unreasonable interference, and second important thing was that use or enjoyment of land. So yeah, the person has created let's suppose this is the building and multi-story building, many people are living here. Okay, and one of them, suppose this person, the person living in the ground floor, if he plays a music at a very high volume, so that will definitely create a nuisance for the other people, right? And that is what, so they are restricted to live peacefully in their respective premises. Okay, they are denied of their comfort is being interfered due to the act of the person who is living in the ground floor, right? So this is this is what we call the person is this is what we call the interference with the use or enjoyment of the land. Okay, but if the person who is walking down the street, if the person walking down the street and there was a guy, vehicles are moving also from this side and that side. Okay, vehicles are moving from here and there. So in that case, if he is getting scared of the vehicles moving just near to him, if he got scared, or if he has a problem with the vehicles, or if he has a problem with the noise, or if he has a problem with the smoke of the vehicle, if he has a dust allergy, and due to that vehicles moves around here, so in that case, he cannot say that no, you have created a nuisance on me, so I will sue you. So in that case he cannot do it, because he is not restricted of his enjoyment of his own land, because right now wherever he is walking, he is walking down the street, so he cannot say that you are creating a nuisance here, I will sue you. He cannot do that because he is not in his premises, and this is a public way, anyone can go there, right? So that's what it is. So the person, the injury here, the nuisance suffered by the plaintiff, that should be for the use of his land, use of his premises only. It's nothing like that. It's it is not suppose he is walking down the street, or if he is going another place and he is getting disturbed there. Suppose he is going to attend the marriage party, and there is a loud music, and he said that I have allergy with the loud music and all that. So he cannot file a suit because he was not restricted, or there was no interference with his enjoyment of his land, because he is in the another's land, right? So simple. And number third essential was the private nuisance was damage. damage. Yeah, so yeah, by the as I told you, there is an example of the tree. Okay, like the defendant has planted a tree in his own premises. The branches and the roots are projected over the land of the plaintiff. So in that case, that he has not created the trespass, but he has created the nuisance to the plaintiff. But if the trees which the branches of the tree, let's suppose okay, it is a fruity plant, okay, let's say it's a lychee tree or say like mango tree. So definitely the branches which comes to the another's land, so definitely the person will say come this side. A person will be more than happy, like if I am here, okay, and my defender and my neighbor, my next door neighbor planted a tree, a very fruity plant and very good plant, and the branches, most of the branches of the tree comes to my side. So obviously I'll be more than happy. Okay, that is not a nuisance. So that is not a nuisance. So that's why, so that is not creating any damage. But if it is not a like good tree, okay, if it is not a nice tree, or if it is not a fruit bearing tree, say it is a banyan tree or it is a peepal tree, so in that case obviously, or bamboo trees, so obviously in that case the defendant will be disturbed, sorry, plaintiff will get disturbed. So that is that kind of nuisance, that is a damage. Okay, so in that case he can file a suit for damage. He can file a suit for damages or say expulsion of the nuisance. Okay, but if it is a fruity plant, so that he has not suffered any loss, right? He is even enjoying that thing. So that's what it is. There should be there's number one is thing, there should be an unreasonable interference. Number two, and that interference to the enjoyment of the land, and that created and that must result in the damage. Okay, so if the three things are there, then that will be tort of nuisance. Okay, that will be the tort of nuisance or say private nuisance, and that is so under the law of tort deals with the private nuisance only actually. Okay, the law of tort doesn't deals with the public nuisance, because public nuisance, there is a provision in the Indian Penal Code as well as in the CRPC section 144. So yeah, so yeah, I told you that it is private nuisance, sorry, public nuisance are dealing under the criminal laws. Okay, and the tort of nuisance is a civil wrong, and that is why private nuisance is deals under the law of tort. That is, yeah, that's what it is. And so there is a case law, okay, Nabel, N-A-B-E-L, Nabel versus Harrison. Okay, so in this case what happened, the plaintiff, so defendant planted a tree in his house, in his premises. Okay, in his premises, and this is highway, this is the land of the plaintiff. Okay, so the defendant planted a tree on his land, and the branches of the tree, okay, the branches of the tree were hanging over the highway. So in that case, the plaintiff filed a suit against the defendant. Because of that tree, the people are getting disturbed here. Okay, because of that tree. So the court held that this is not a private nuisance. The court said that this is not a private nuisance, since you are not getting disturbed personally in person. So this is not a private nuisance. The court has said like that. Okay, so this is what it is. I hope you enjoy this video, and this is all about nuisance. And if you still have any doubt, I have tried my best to make you understand about this topic. If you still have any doubt, queries, you can comment down, or you can follow me on my Instagram. You can ask me there, you can connect with me. So yeah, I hope you have find this video helpful, and if it did help you, then definitely I expect a like from you. And if you like this video, please comment. If you do not like this video, if you want something more in this video, then please do let me know. So yeah, in total, thank you so much for watching this video. Have a great day, guys.